Okay, so we are still looking at influences on human resources, and today we're going to start looking at legal. So, legal influences in the human resource management process. This is influence number 2. Okay, the first thing we need to look at is the current legal framework. So, the main legislation around employment in Australia is the Fair Work Act of 2009. Notice the CTH in brackets after that, meaning it's a Commonwealth law, a federal law, covers all workers in Australia. Okay, so this is a decentralised industrial relations system where employers and employees negotiate wages and working conditions in the individual workplace through collective or individual bargaining and without the involvement of tribunals. So what does that actually mean? So when it says decentralised, it means that it's not all happening in one place, that it is a spread out type of a system. So we have employers and employees negotiating wages and working conditions in individual workplaces, so individual businesses or within individual industries. Okay, so collective bargaining means that a group of workers get together to negotiate their wages and working conditions, whereas individual bargaining is a one-on-one. So let's say in a large business, an individual person might go to their employer and negotiate a separate contract of employment, which shows their wages and working conditions, which is different to maybe what somebody else in that same business is doing. Okay, so the Fair Work Act is the key federal legislation which governs employment and workplace relations in Australia and applies to most Australian employers. The Fair Work Act is supplemented by other federal, state and territory laws relating to specific areas, including things like workplace surveillance and anti-discrimination. So, as an example, anti-discrimination laws, they are state laws. It's not an actual one federal law that covers everybody when it comes to discrimination. So, within each state, employers have to also follow the guidelines set out by state legislation. Okay, the Fair Work Australia Tribunal is a panel of judges who settles disputes and sets the minimum wage rate. And as you can see, there is a video attached to this PowerPoint. Please go to the Google Classroom and click on that to see what happens. Hang on. Okay, so the employment contract is a legally binding formal agreement between employer and employee. The agreement must meet the requirements from 3 different organisations: the Court, Parliament and the Fair Work Australia Tribunal. The Court looks at common law rights and obligations. Parliament looks towards minimum employment standards, and Fair Work Australia Tribunal looks at minimum wage rates. Okay, so when it comes to the court's common law rights and obligations, breaching these can result in court action. So if employers and employees are not doing as they should be, it can lead to actions in court. Okay, so what are the obligations of employers? Employers must look at the payment of income and expenses as indicated in the award or other agreement and reimburse employees as appropriate. That means they have to pay people what they deserve. Employers need to meet the requirements of industrial relations legislation, such as discrimination. Employers have a duty of care, as identified by occupational health and safety regulations, to provide reasonable care and safety for employees. All of that is fair and reasonable. Employees also have obligations under common law. They must obey lawful and reasonable commands of the employer. Notice the word reasonable. An employer cannot ask their employee to do just anything. It has to be reasonable. An employee is expected to use care and skill in performing their work activities and also to act in good faith and in the interests of the employer. So employees can't go and sell company secrets. They cannot deliberately do something to tamper with whatever's being produced by the business. They cannot go around bad-mouthing the business. They have to act in good faith. Okay, Parliament looks at minimum employment standards. So under the Fair Work Act, there are 10 standards. They look at maximum weekly hours of work, which is 38 hours per week, unless there is a specifically negotiated clause around this in an employment contract. Any work over or above 38 hours per week would require the employee to receive overtime. They look at requests for flexible working arrangements. They look at parental leave and related entitlements, annual leave, personal carers leave and compassionate leave, community service leave, long service leave, public holidays. They make sure that notice of termination and redundancy payments are done correctly, and there is a provision of a Fair Work information statement, so employees and employers know what's going on. Okay, attached here we have 2 clips. They are informative, they are also a little bit of fun. So if you click on the Mythbusters and the Myth Busted on the Google Classrooms version of the PowerPoint slides, you can watch those. Okay, Fair Work Australia Tribunal, they're looking at the minimum wage rates. So under the Act, minimum wage is determined by 1. The award or agreement that covers the employee. The rate of pay cannot be less than the minimum wage. Currently, the full-time minimum wage for adults in Australia is $19.49 per hour, or $740.80 per week. Second thing they look at is the national minimum wage. This applies to employees who aren't covered by awards or agreements and is reviewed annually by a panel of 7 members of Fair Work Australia to try and keep people from obviously living under the poverty line. All employees in Australia will have a common law contract of employment, whether that's written or unwritten, which specifies terms and conditions with their employer. The employment contract may be based on a workplace agreement between an employer and a group of employees or industry-based awards. So, for example, if you have a job, which many of you do, you more than likely did not sign a specific employment contract, but you are covered under common law, so your boss has to pay you fairly, provide a safe workplace, you are expected to do the right thing. Those things are already implied, even if you haven't had access to signing a particular contract. All right, see you in a minute.